Okay, 2 says the family court judge can do a bunch of things, but here it says administer oath, take acknowledgments, issue a subpoena ducis tecum, order a warrant, hear and decide motions relating to child support subpoenas. So it's A, all of the above. 3, any day of the week, any time, at day or night, in any part of New York State, that's true. So family court warrant of arrest can be executed same way, like Superior Court warrant of arrest. Question 4 says, which, if any, of the following are true when a person appears in family court and requests a TOP? 1, such person is entitled to file a petition without delay on the same day he or she appears in family court. That's true. And then a hearing has to be held either that day or the next day family court is open. So just remember, if they come in at 5 o'clock on Friday, you have to let them file the petition. And you'll get some nice overtime, hopefully. 5, this says, if the court orders that a respondent or petitioner's address is to remain confidential, papers directed to that person may be served on, and this is right out of the statute, it says the clerk or a disinterested person designated by the court, so the answer is C. Okay, 158, this is question 6. Child under the age of 16, so 0 to 15, is in protective custody as a material witness. The order can be for 14 days, but they can get up to 2 extensions for a total up to 42 days. Who is entitled to a government-paid attorney when they can't afford an attorney? So the answer was 1, 2, and 3, but not 4. So I think that was B, but basically it's respondent in 10, 10A, and 10C, the petitioner and or respondent in a family offense, and the parent of any child who opposes the adoption of the child. So the reason 4 is wrong is because it's only the respondent in an Article 5 to establish paternity. And once the paternity is established, they don't have the right anymore to counsel. I think on every single test, there's been a question in relation to this. Either they're asking about which adult gets an attorney or which child gets an attorney, and when does the court have to appoint the attorney for the child. It's usually the answer that they give. If you're not sure, it's going to be the earliest possible time on the child one. 305.1, this is number 8. If a private person takes a juvenile into custody, he or she must, without unnecessary delay, bring the juvenile to their home, police or peace officer, and the reason number 2 is false is because they can't bring them to housing court, can't bring them to criminal court. You gotta bring them to family court. Number 9, a copy of a family court appearance ticket shall be forwarded by the issuing agency to the complainant, respondent, the parent, and probation service within 24 hours of issuance. Proceeding to adjudicate a person a JD may be originated, and it's actually only be originated by a presentment agency filing a petition. So E4 only. And the number 9 was A, 24 hours. 11, who must consent? This is a challengeable question. Whom, if any, of the following must consent to the conversion of a petition to find a person is a juvenile delinquent to a PINS petition? So it's challengeable for 2 reasons. 1, I don't agree it's challengeable with, but Frank does, so I'll explain that one. That one is that it does not specifically say it does not specifically say the court has to consent. And generally, when they're talking about the word consent, that's not usually the court. It's usually permission. The court permits things and then other people consent. So that's the one reason it's challengeable. The second reason it's challengeable is because it doesn't specify here that this is when this is happening. So if it's after the conclusion of a dispositional hearing, the only person that's to consent is the respondent. Presentment agency is then out of the equation. Okay, but either way, that was designed to make you look at the section, know that who can make a motion for this, and it's only the respondent or the court on its own motion.
What?
It's only respondent or sua sponte on who can make, yeah, it is.
No. Look at this section.
No, I don't have my book. You look at the section. It's only those 2. Does anyone think that is incorrect? No, it's, okay. No, the answer key is correct. I'm just explaining why it could be challengeable. In my opinion, you would lose both challenges on them, but it's still a challengeable question. I would still try to challenge it, especially if I got it wrong, but I don't think that you could make a strong enough argument to win the challenge on either of them. In a juvenile delinquency proceeding, if a respondent receives an ACD, it shall be for 6 months. So pretty much family offense and Mary Jane, that's 1 year, but pretty much everything else is 6 months. Except maybe Article 10 might be a year, I forget. The provision 13 says the provisions of the CPLR and any rules regulating judicial notice and authentication and proof of records shall, unless otherwise prescribed by this act, apply to proceedings under this act to the extent they are appropriate. And that's because even though the family court does have Article 3 and 7, which are a little more like on the criminal side, essentially they are still civil proceedings. There's no jury trials in family court. So, question 14, this is in 117. Proceedings in the family court outside the city of New York involving a JD proceeding under Article 3 involving designated felonies shall have preference over every other proceeding except proceedings under Article 10. And the reason that in the city of New York there's no reason for this is because in New York City there is a designated felony act part. 161, this is in number 15. Oh, so I'm sorry, the answer was A. 15, the days and hours family court is open shall be as provided by rule of court. So maybe one of you knows an administrative judge in family court that's willing to change us to a 4-day work week, but that would be nice. But it does say as by rule of court. It doesn't say 9 to 5 or anything else.
Suffolk County, the administrative judge had changed his hours from 8 to 4 before the fire.
Did you guys get 8 to 4?
Yeah, a lot of people got 8 to 4.
Wow.
Staff had to go 8 to 4, so there was rotation in there, 8 to 4. It's the only part that was 8.
So maybe you all, if you didn't know this, now you'll remember it, that they can actually do it by rule of court. Change the hours. Okay, so the next one says, the records of any proceeding in the family court shall not be open to indiscriminate public inspection. I think on one of the other classes they have notes on this, and it doesn't use the word indiscriminate, so just be careful. It does say indiscriminate in the statute, and yes, it does make a difference. 17, a family court summons may be signed by its clerk or judge only. So answer B. 18, if the respondent in a JD petition is detained, he or she should appear in family court within 72 hours after the petition is filed or the next day, family court's in session, whichever is sooner. So in case there's, a blizzard week or something, then that's why they have to have it in there, I guess. Because you would think they could just say the next day family court's in session, but it has to be within 72 hours. So I guess if 72 hours goes by, like after Hurricane Sandy, they were closed, a lot of the courts were closed for longer than 72 hours at a time, they would have to figure out something else. Now, 19 says, so now we're talking about after the initial appearance, a respondent in a JD proceeding is ordered detained. The family court must schedule a probable cause hearing, and it's within 3 days of the initial appearance or within 4 days of the original petition being filed, whichever is earlier. So another clerk that I'm studying with at lunchtime, who's also taken the 3 with us, explained why this is. So that if there's a probable cause hearing, the person is detained. That's the only way they'll ever schedule a probable cause hearing. Okay, so even though in criminal you can get a felony hearing, whether or not, if you make bail on a felony hearing, you can still get a felony hearing. In Family Court Article 3, the only time they're ever having the probable cause hearing is if someone's detained. So I didn't personally understand that, so that's why I'm explaining it. 20, JD proceedings should be filed in the county where the alleged act occurred. So that's like criminal. 21, a JD is a person over 7 and less than 16 or starting October 1st, 2018, person over 7 and less than 17, and commencing 10/1/19, a person over 7 and less than 18. 22, the family court may place in protective custody a person under 16 who is a material witness. So I guess I haven't updated that. But,
Material witness is still 16, they're not a respondent.
well, under 16, so 0 to 15.
Repeat of a question we already had.
Yeah, okay, sorry. If an adult respondent is arrested under the Family Court Act when the family court is not in session, they will be taken to the most accessible magistrate. Answer is D. So now 375.1, this is talking about a termination in favor of the respondent. And the only way that this is not sealed is if with not less than 8 days notice to the respondent by written motion, the presentment agency demonstrates to the court's satisfaction that the interest of justice requires otherwise. Can't even fathom how this could happen, but it's in there. Or the court on its own decides that, with not less than 8 days notice, that the interests of justice require otherwise and states the reason for the determination on the record, the clerk of the court shall immediately notify, so it's this list of 4 people, the respondent's attorney, the director of the presentment agency, the head of the police department or law enforcement agency, and the head of the probation department. The records of the action shall be sealed. So when you're reading this, maybe compare this to Family Court Act 354.1 sub 2, because then the notification is different in that one.
Mary, what was that 354?
354.1 subdivision 2. You're welcome. 25, in general, service of summons and petition for JD has to be served at least 24 hours before the time stated therein for appearance. 26 is, thankfully they didn't change the motion time here. It's just a regular CPLR motion time. Motion to dismiss 8 days prior and answering affidavits 2. So the answer is C. 27, proof of the fact finding must be beyond a reasonable doubt, same as in a criminal complaint. So answer B for number 27. Okay, this question, I would honestly, if I were you, I would skip all of these because they screwed up the section so bad I wouldn't even waste my time memorizing it. But basically the statute, first of all, they messed up the statute. It does not say respondent, it says defendant, so there's problem 1. The next problem is that the public health law was amended to say that whenever this test or any kind of test like this is done, they have to notify both the person that got the test and the person that made the application. So in one section they say the victim and the respondent, okay? And then in another section, in the same it's the same issue in the CPL, they say the person making the application.
You know why? The difference is it says in the second part where it says person making application, it's HIV-related information. They use that same language in the CPL.
Right, so it's test results. Now, HIV-related information, how you could possibly not, I just don't think that they're going to go anywhere near this question, and if they do, it is going to be the 2 time rules. The 2 time rules are identical in the CPLR and in the Family Court Act, and it's that the person has to request the test no later than 10 days after the conviction or finding, and then the test has to be performed within 15 days by like a public, it can't be performed by a private doctor, it has to be a public thing. Okay, so that's the only thing I would know for the whole HIV crap. It's 10-15 public health official thing. Question 30, if the respondent in the JD has committed any felony, the initial period of placement shall not exceed 18 months. So it doesn't say designated felony, just any felony, 18 months. Answer B. 31, if it's a misdemeanor, shall not exceed 12 months. So C. 32, if action has resulted in a finding of delinquency other than a finding the respondent committed a designated felony, the court may, in the interest of justice and upon motion of respondent, order the sealing of the appropriate records. So also, I just want to point out, because I'm not sure that this question was on this quiz, they changed the definition of what a designated Class A felony act is. It used to be only like the 4 things that were in the paragraph of designated felony. It now says that a designated Class A felony act is any felony that if committed by an adult would be a Class A felony act. So just in case they want to ask a new question on that, just know that. The next one is true. Family court can order expungement of records. I think they're the only court that can order that.
Right?
Family court can order, are they the only court that can order that? Family and surrogates?
Yeah, expungement. That's the only time I've seen that
Yeah, I
word.
think it's only those two.
In
But
our
for our
statutes.
test purpose, it's only family court.
It's not the statute, not the section.
I had it download. I had it printed
It's
off
on,
the
it's
computer.
online.
I
She
had it
found
printed
it
off the
online.
computer.
I was gonna say, it's not in the book.
No, I didn't have it in my book. I went online in the laws of New York, and I printed it out and I pasted it in my book. Yeah, it wasn't in my book. I'm looking
Yeah,
at
so
the
the
question,
only,
I'm
the only
looking
reason
at
that I knew that it was still in existence is because Christine actually went online and found it. So, that's why. So thanks, Christine. Number 34, no person is a criminal if they get a JD conviction. Simple as that. 35, no adjudication under FCA Article 3 shall operate as a forfeiture of any right or privilege or disqualification. Cross off the word except because it's no exceptions. It's period. So D, none of the above. 36, during a JD placement, the Division of Youth should report on the status, adjustment, and progress of the respondent at least once every 6 months. 365.1, this is number 37, an appeal for a family court decision in a JD petition is taken to the appellate division. And also, I have a note here that there's an automatic preference pursuant to the CPLR. You don't have to make a motion. It's not like in regular civil where you're saying you are entitled to a preference. You normally have to make a motion for that. In Article 3, 7, and 10 of family court, it's an automatic statutory preference when you appeal to the appellate division. 38, a hearing on a TOP sought in family court. I think I did this already, so skip that. It was a repeat of the question. Answer was D. 39, okay, another pain in the ass question, right? All right, so let me go through all of
I
these.
never write pain in the ass questions.
This was a pain in the ass question, okay? Number 1, a respondent, okay, number 1 was not too bad. Respondent in Article 10 or 10A, yes, of course. Petitioner in a proceeding under Part 8 of Article 10. Now, Part 8 of Article 10, if you didn't know, which I'm sure you all do know, is visitation of minors in foster care. So that's when the kid is taken away and the parent wants to visit them. So that's why they get counsel. 3, a petitioner or respondent under Article 8. Now, this one, if you were confused because it didn't say and, this is one of the situations where the word or versus and is a latent defect. It means essentially the same thing in this particular context. Number 4, I personally had trouble with because it says any person facing contempt. Generally, that is true. Okay, so even though there is a very, very limited, narrow, rare situation where they wouldn't get it, which is if you commit the contempt in front of the judge somehow, then the judge wants to put you in, they're not going to say, hold on, let me find an 18B floating around before I put you in. That's so limited that didn't qualify enough to make this wrong. It's generally, if someone's facing contempt, they are entitled to counsel. Number 5, a parent opposing the adoption of their child. This one's easy, yes. Okay, number 6, again, I had trouble with this one. It says a respondent in the petition under Article 5. Now, the reason that this is wrong is because they're only entitled as far as the establishment of paternity. So sometimes you get into family court, the very first day they get in there, the guy's like, yeah, I'm the father, signs that, there's no affiliation that day. The legislature wasn't realizing that we were going to convert that thing into an F docket. They were just assuming, because if you look at the definition of what Article 5 says, it says Article 5 is proceedings to determine paternity and for the support of children born out of wedlock as set forth in Article 5. So once there's an establishment of paternity, the right to counsel is over. Okay? So that's why that was wrong. But
The
yeah.
statute actually reads, respond in any proceeding under Article 5 in relation to the establishment of paternity.
Yes, and that's what it is. That's what it is. So, but if you had trouble with that one, you were not alone.
Who's doing the civil quiz? While civil quiz comes up, I want everyone to open their book at family court and find the section 340,
Okay, yeah.
311.4.
Once I actually took the time to look at it, it was a really, really good teaching question. It really helped me understand it when I spent the time to look at it. But initially, I did get it wrong. So because I thought, wait a minute, respond in Article 5. Isn't Article 5 the whole point of that damn article is paternity? Not necessarily.
Everybody got their book open. 311.4. Wave when you got it open. 311.4. Look at subdivision 1, and we're going to contrast it with subdivision 2. Subdivision 1 says, and this is what? This is juvenile delinquency. At any time in a proceeding, the court, upon motion of the respondent or its own motion, may, with the consent of the presentment agency and the consent of the respondent, substitute JD with PINs. Look at what subdivision 2 says.
He's reviewing question 11, by the way, in case anyone was lost.
Subdivision 2 says, at the conclusion of the dispositional hearing, the consent of the presentment agency is no longer required.
I mean, may need you to come in from the
So
bullpen.
if you get a question about converting JD to PINs, be very careful to look when. When. Why is the dispositional hearing the end of the dispositional hearing? Because essentially what's happened, the presentment agency's role is over. Now it's the role of the court. What are we going to do with this kid? Okay, and that's why it's the presentment agency's consent isn't listed. All right, but that's one that you really got to be careful about. Okay, come on up.
Wait, we're not done. We have like 20 more questions, 30
Oh my
more
God, what are
questions
you
to
talking
go.
about? I thought you were finished. Go ahead. Who wrote all these questions?
Hence the interlude into Article 5.
Okay, so anyway, I'll try to hurry up. We'll try to speed it up a little. All right, next is for a minor to waive counsel, the court must find, among other things, that they have maturity, and the standard of proof is clear and convincing. The attorney has to participate in the hearing, so this can only be rebutted after the attorney is assigned and participates in the hearing. So clear and convincing, you don't see it too often. It's severe and repeated abuse is clear and convincing. This is clear and convincing, and then sex offenders is clear and convincing. That's okay, yeah, but isn't that part of termination of parental rights? Yeah. So termination of parental rights, severe repeated abuse, this thing, and then the sex offender thing. But I'm sure there's plenty of others I'm not thinking of, but I'm trying to, give you some context. That it's not common. It's usually preponderance or beyond a reasonable doubt, but sometimes you see this. And clear and convincing proof is the same as clear and convincing evidence, right?
What?
Proof and evidence is the same thing.
No, it's not.
Oh, it's not? Okay.
No.
There's a difference? All right. I didn't know that. I don't think OCA knows that either, so don't worry.
The problem is there
lot
are
of things
places
we
in the
see.
statute where if they say clear and convincing evidence or clear and convincing proof, evidence and proof are the same thing. But there are plenty of other places in the statute where evidence is what creates proof.
Okay, well, for our purposes, for taking this test,
Okay.
because I'm not a lawyer, so it's the same damn thing to me, I think.
No, Mary, under 3, for the fact finding, the evidence is like CRAM,
Yeah.
but the proof is BRD.
Right.
So
Okay.
it's really not the same in this.
Yeah, but that's because proof beyond a reasonable doubt is the highest possible standard.
Right.
That's the
So-
The evidence is still by competent, relevant material.
just
The proof in the same thing, the fact finding. And then for the dispositional, it's relevant
It's
material.
relevant, yeah, but that's the type of evidence. That's not the standard of proof.
Standard is POE.
But the reason I'm saying that they don't really differentiate in this section is because it says the standard of proof, and then they're using the phrasing evidence, clear and convincing evidence. Okay. Where am I? 41. Okay, so Here's a nice time rule, thank goodness. Respondent is not detained. Initial appearance shall be held as soon as practicable and absent good cause, 10 days. So not detained equals as soon as practicable or 10 days. Initial appearance in a family court juvenile delinquency may be adjourned no longer than 72 hours or the next court day, whichever is sooner, to enable the counsel to appear before the court. 43. Okay, so this one says, at the initial appearance, if the respondent denies a charge contained in the petition and the court determines that he shall be detained for more than 3 days pending the fact-finding hearing, the court shall schedule a probable cause hearing within 3 days following the initial appearance or 4 days following the filing of the petition, whichever occurs first. So I think it's a repeat, but yeah, 3 days or 4 days. And that's only if he's detained, they have a probable cause. Okay, so this next one I'm going to try to abbreviate. Basically, ABC felony plus detention equals 14 days. DE felony, misdemeanor plus detention equals 3 days. At liberty, fact-finding equals 60 days. All right, answer is D. 45. If the respondent in a JD is not in detention, the fact-finding hearing shall commence not more than 60 days after conclusion of the initial appearance. This one is really long, so this 46, you need 1 and 2. It has to be incorporated under laws of New York, actually have its business or home within New York State, and then you need either 3 or 4. So they either have to be approved or visited or supervised by Department of Family Assistance, or they consent and submit to the approval of that department. So the answer was A. 47. This is cross out number 5, then you have a study question. Which of the following has to be included in a certificate or affirmation or affidavit of attempted service by an officer? 1. Name of party attempted to be served. True. Papers attempted to be served. True. 3. Date and time of attempted service. True. 4. Address of attempted service, or in the event there is no address, the place and manner of attempted service. So answer is D. 48, this is true. In general, any motion to vacate or modify an order of protection or a TOP shall be on notice to the non-moving party and the child's attorney, if any. This one, this is so annoying, this one. A desk officer may in such place take bail from the, okay, so basically, if it's outside of New York City, it's 11 a.m. and 8 a.m. the next morning. This is talking about cash police bail, okay? And if it's in New York City, it's 2 p.m. and 8 a.m. the next morning. And then it says the amount of cash bail shall be fixed in the warrant.
Can you explain New York City?
New York City.
New York City.
Okay, so this number 50, OCA can enter into an agreement with legal aid to get attorneys for children. An agreement may be terminated by OCA by serving notice on the society 60 days prior to the determination. No agreement may be for more than 1 year, but obviously they can have successive extensions. Okay, number 51. Fill in the blanks. Upon receipt of a fingerprint report of an alleged juvenile delinquent, the recipient agency must promptly transmit 2 copies to the family court and 2 copies to the presentment agency, who shall furnish a copy to the respondent's attorney. All right, number 52. If an Article 3 finding of the family court is appealed by the respondent as appellant, he must serve a notice of the appeal on the presentment agency. If the presentment agency is the appellant, it must serve a notice of appeal upon the respondent and upon the attorney who last appeared for him in family court. Following the filing with him of a notice of appeal in duplicate, the clerk of the family court must endorse upon such instruments the filing date and must transmit the duplicate notice to the clerk of the appropriate appellate division of Supreme Court. So I spent time on that one because it's actually talking about something a clerk does. 53, where an officer or designated person obliged to perform service is unable to complete service of a TOP or order of protection, the officer or designated person shall provide the court with proof of attempted service. So it would be in the form of a certificate, I think, if it's an officer, but this question also says a designated person. So it's just proof of attempted service. Okay, number 54. John was arrested pursuant to a family court petition filed against him. He complained that he had never been served with any family court petition. Pursuant to the FCA, John should be served with a copy of the petition at the time of his first court appearance. Very, very, very different than civil. Number 55. Linda, a Queens resident, was placed on probation by Nassau Family Court and allegedly committed a violation of her probation in Suffolk. Which family court may hear the allegation of her violation of probation? And the answer was Nassau or Suffolk only. It doesn't matter that she lives in Queens. 56. 217. Family court shall direct the filing of an order within 20 days after a decision of the court. It's just like a provisional remedy. It's the same as a provisional remedy in civil. 57. Every witness more than 9 years of age may testify under oath. So that's 9 and up. 0 to 8, not necessarily. Generally they can't, 0 to 8. Okay. Number 114. Question 58, FCA 114. When used in the Family Court Act, exclusive original jurisdiction means that a proceeding must be commenced in the family court in the manner prescribed in this act, which means usually by filing a petition. The provisions of this act shall in no way limit or impair the jurisdiction of the Supreme Court as set forth in Section 7 of Article 6 of the Constitution of the State of New York. It's basically exclusive original jurisdiction far and away. 151, this is number 59. Judges of family court are magistrates. 154-C. No order of protection may direct any party to observe the conditions of the order unless the party requesting the order has served and filed a petition or counterclaim in accordance with, and then there's the list of articles, and I didn't do this question, so I don't know the answer, I'm sorry. 4, 5, 6, and 8, thank you.
You know why? Because under Article 3, you can file your petition before.
And Article 10, same thing. Yeah. All right, so
Petitions.
4, 5, 6, and 8.
So it's D.
So the answer is D.
Because 10, so you can't protect?
For 10, you don't have to do all this crap. You can just get one in 10. The judge can just have one before the petition is filed. So if it's like there's a removal of the child or something prior to the petition, then they can do an order of protection without a petition being filed or served. So number 61, so this basically says from 0 to 9, no detention. The detention of a child under 10 in a secure facility shall not be directed under any provisions of Article 3. So basically no jail for 0 to 9. I think this is a repeat. Is this number 62 a repeat? Okay, skip 62, we did it already. We did 63, that's a repeat. 64, an order dismissing an Article 3 petition in the interest of justice may be made on motion of presentment agency, respondent of the court, or the court. Upon issuing such order, the court must set forth its reasons thereon upon the record. So, like with a microphone, you know, they have to do it on the record, not in writing. This is 65. Which, if any, of the following shall ensure that a court order of protection and TOP issued by the court under 3, 4, 5, 6, 7, 8, or 10 of this act is translated into the appropriate language? And the answer is OCA. Now, obviously, if you work in family court, you know we got like 3 languages in there. A lot more than that, they got a long way to go. 66. This is true. In every case, a party to a proceeding described in question 65 shall be given a copy of the order of protection or TOP in both English and the language to which it was translated. A nice study question in number 67. A child shall not be questioned pursuant to this section unless he and a person required to be notified, if present, have been advised. This is like the Miranda warnings, basically. 1, the child's right to remain silent. 2, statements made by the child may be used in a court of law. 3, of the child's right to have an attorney present at the time of questioning, and 4, of the child's right to have an attorney provided for him without charge and indigent. So answer is A, all of them. Is number 68 a repeat also? Okay, so
But Mary, the section on 67 is incorrect.
what is it really?
It's 305.2.
Okay, so number 67, you could please change the section to say 305.2. Uh, 68 is a repeat. 69, the family court has jurisdiction to direct commencement of proceedings to suspend driver's license, recreational licenses, a bunch of licenses for persons who are delinquent on their child support, or combined child and spousal support, or who have failed after receiving notice to comply with summonses, subpoenas, or warrants relating to paternity and child support. Such jurisdiction shall include jurisdiction over all boards, departments, authorities, or offices of the state. True. Judges of the family court and magistrates. 71, true. The family court may send process or other mandates in any manner in which it has jurisdiction into any county of the state for service or execution. 72, in any proceeding in the family court, a copy of the petition therein shall be served upon the respondent at the time of the first court appearance by the respondent, and if not, at the time of service of process, and then it's not practicable at the first appearance. And then true, 73 says, the provisions of Article 40 of the CPL concerning double jeopardy shall apply to juvenile delinquency. Thank goodness we were finished with that one.
Okay. Well, Mary comes up to do civils. Let me remind you, the reason the order of protection of TOP has to be given in the language of the person and English is so if they go to an attorney, they can show the attorney the English one. So the
Yeah, well,
attorney
OCA's got a long way to go
the
for that.
attorney made it, the hiring may not read the person's native language.
That we didn't have.
So it's really that reason why they're
If
at
something
both.
is removed out of penal, I looked at penal.
Yeah.
What at 7:25? The clerk has to schedule a hearing 7 days after.
Yes,
It's not-
so-
I'm just gonna put this out there, it's not a test question, but it's something
It is a
that the
good
clerk
time rule to
does,
know.
and it's a good time rule to know. So when something is removed out of criminal court under 725, and it has 10 days for the removal, just like the SCI goes up, everything kind of like follows the same thing for the removals. The clerk of the court schedules the appearance for the hearing 7 days after the filing of the order of removal in the family court. So it's something, sorry? I know it
She's
is.
telling people because it wasn't a question on the test.
Yeah, so that's the only, I think.
So write that on your paper somewhere.
Provisions would be 7 days.
After the filing in the family court of the 725 order. Right, Frank?
Thank you.
Let's roll.
Say it again?
No, because it's in the Family Court Act also. But it's in the Family Court Act, which is on the test.
No,
No, it's in I think it's in Article 1 somewhere, but
no, it's in 3.
it's in 3?
Yeah.
Okay. But it's in both. It's in definitely in the Family Court Act, so just maybe make a note of it
Yeah,
somewhere.
I mean, it's an extra if you want to take it. What?
You already had the fact finding in 17.
Yeah.
Right,
And it actually says the word deemed in statute.
right. So they don't have that hearing. It goes straight to the dispositional hearing. Okay? All right, so surprise civil quiz number 1. Which of the